Hi there. This video I wanted to look at a decision out of the DC Circuit on a default judgment case, which ordinarily default judgments aren't that interesting, but I think it's actually interesting for two reasons. Number one, I've often met with clients who don't know how to respond to lawsuits if they're served with a complaint. And I think this case outlines the drastic outcome that can happen if you don't actually respond within the time permitted and you don't follow the rules for actually responding to the complaint. Number two, I think this is helpful in explaining an interesting concept in tax law about reporting on foreign bank accounts, and really the downside and the potential liability that you're exposing to yourself to if you don't report the accounts correctly. So let's jump right into the decision. Americans who live abroad sometimes try to store their money in offshore accounts to evade their taxes. Such efforts are upended, however, when their foreign banking institutions report them and the Internal Revenue Service comes to collect. In this case, the United States seeks $2,057,157.44 from one such France-based consultant, Don Debrick, for his willful failure to report his interest in foreign financial accounts in 2010 and 2011 pursuant to the Report of Foreign Bank and Financial Accounts, or FBAR, a provision that requires taxpayers with foreign accounts that exceed $10,000 in aggregate value to report them to the government each year. As Debrick never responded to the complaint following proper local service, the clerk of court entered a default on February 4th, 2025. So you'll notice that Judge Boasberg, who's the chief judge in the DC Circuit, mentions that the government sought and received a default by the clerk. So what ends up happening is when a defendant doesn't respond within the time permitted, the plaintiff or a complainant is able to file a request for default with the clerk's office. And the clerk will essentially just note that the default has entered, which means that an answer or a response of pleading has not been filed. That isn't the same thing as actually getting a judgment, so you don't win by default automatically if there's a default entered. It actually takes a motion for default judgment, which is what we have here. So the government actually filed a motion asking the court to say, okay, this defendant hasn't responded, and by virtue of that, the plaintiff, or in this case the U.S. government, is entitled to judgment and is entitled to the relief that's sought. The government now moves for default judgment pursuant to Federal Rule Civil Procedure 55. Since the government has sufficiently demonstrated that the allegations in its complaint warrant such judgment, the court will grant the motion. Debrick is a United States citizen who lives in Châteauneuf, France, and works as an oil and gas consultant. Defendant had at least 6 foreign financial accounts during 2010 and 2011. The aggregate value of the balance of the accounts totaled almost $3 million in 2010 and $3.4 million in 2011, bringing him well within the FBAR ambit. Yet defendant reported only 3 accounts totaling $28,883 in his 2010 FBAR filing, and he did not timely file an FBAR for 2011. Hypo Swiss shook things up when it disclosed its relationship with the defendant to the IRS as part of the Swiss bank program's non-prosecution agreement. Debrick could have resolved his situation by paying the reduced penalty, but he refused to do so, and then attempted to transfer OVDP's non-willful program by claiming under penalty of perjury that he had no control over and thus did not need to report the accounts held by his consulting firm or his trusts. So the crazy part in this case is that it was completely avoidable. At the time that these violations occurred, there was actually a program in place that allowed you to amend your filings that would have brought you back into compliance. And we're really just looking at income that would accrue on a savings account, substantially less than the fines that we're about to see imposed by the court. And as you're going to see, Judge Boasberg is actually going to go through an analysis of whether default judgment is appropriate. And the reason behind that is courts want to make sure that the factual underpinnings of the complaint are well-pled, or well-pleaded. So well-pleaded complaint simply means that if we assume the allegations are true in the complaint, does that entitle the government to judgment? If we believe everything that the government's saying, is that enough to rule in their favor? And as we'll see, Judge Boasberg thinks that that's the case. The IRS assessed FBAR penalties against Debrick on April 14, 2022 for calendar years 2010 and 2011, and those assessments amounted to $782,000 and $920,000. That combined balance had grown to $2,057,000 as of April of 2025 through interest at 1% per year and late payment penalties of 6% per year allowed by federal law. A court may enter default judgment when the party against whom a judgment is sought has failed to plead or otherwise defend, and that failure is shown by affidavit or otherwise. Once default is entered, the defendant is deemed to admit every well-pleaded allegation in the complaint. Nevertheless, modern courts are reluctant to enter and enforce judgments unwarranted by the facts. A district court may still deny an application for default judgment when the allegations of the complaint, even if true, are legally insufficient to make out a claim. The government was required to provide direct notice to any person who reasonably appeared to be a potential claimant on the facts known to it, and to send such notice by means reasonably calculated to reach the potential claimant. For a defendant residing abroad, service must be made pursuant to Federal Rules of Civil Procedure 4F, and the defendant need not be served within the usual 90 days after the complaint is filed. The government, through French firms, effected service on defendant at his French home address on December 18, 2024, in accordance with local law. So you're going to see here that Judge Boasberg actually goes through each of the elements that the government has to prove, so items 1 through 7, and methodically the judge goes through and makes sure that the facts alleged by the government are sufficient to prove the case. And as you'll see, the judge reaches that conclusion pretty easily. There could be an instance where that might not be the case. So if you have a frivolous lawsuit where a plaintiff brings a complaint and says, the defendant owes me $100,000 because I don't like the color of his car, a court should at that point find that there isn't a sufficient factual predicate to actually give relief in that case. There aren't sufficient facts to support their claims, but that's fairly rare. As long as the plaintiff files facts sufficient to find each element of the action that's been alleged, that's going to be sufficient to enter a default judgment. Under 31 U.S.C. 5314A, a taxpayer must file reports when the person makes a transaction or maintains a relation for any person with a foreign financial agency. This means that anyone having a financial interest in or signature or other authority over a bank, securities, or other financial account over $10,000 in foreign country shall report such relationship for each year which such relationship exists. Willful failure to do so can result in penalties equal to 50% of the value of the undisclosed account or $100,000, whichever is greater. The government may thus prevail in its request for a default judgment by showing that 1. Debrick was a U.S. citizen or a qualified person during 2010 and 2011. 2. He had a financial interest in a signatory authority over the account at issue during those years. The account balance exceeded $10,000. 4. The account was in a foreign country. 5. He failed to disclose the account. 6. The failure was willful, and the amount of the proposed penalty is proper. The government has satisfied the above elements. First, Debrick was at all relevant times and remains today a U.S. citizen. Second, as explained above, he had a clear interest in his 6 foreign financial accounts. Third, the balance of his accounts in 2010 was $2.9 million and $3.4 million, respectively, which well exceeds the $10,000 threshold. Fourth, each of the 6 accounts was based in either Switzerland or France. Fifth, he failed to disclose 3 accounts. The 6th element of willfulness is also clearly shown here. The defendant filed self-prepared FBARs for all years prior to 2011, in addition to his income tax returns. So at a minimum, he clearly knew that he was the subject of reporting requirements. The government further alleges that the behavior was a part of defendant's pattern of concealing tax information from the United States and other taxing authorities. On each of his pre-2011 FBARs, for instance, Debrick reported 3 or 4 foreign accounts totaling roughly $20,000. On his original U.S. income tax returns for 2010 and 2011, he reported neither his consulting income nor his rental income accrued from his 3 French properties, denied that he was the grantor of a foreign trust, and failed to list his Switzerland accounts. To French authorities, he also failed to report his consulting income, even though he claimed significant foreign tax credits from the United States. When defendant was notified by Credit Suisse in 2009 that it would report its relationship with him to the U.S., he transferred millions of dollars to accounts at other banks, Hypo Suisse and RBS Coutts. Either willful blindness or reckless disregard satisfies the mental state required for the 6th element, and defendant's actions rise to that level here. As to the 7th element, the Treasury Department's assessment of $2,057,000 falls below the maximum penalty. So in conclusion, the court thus finds that the government has met its burden and will impose the default judgment sought. So we have a case here where there is actually a default judgment that entered that's over $2 million. and it was completely avoidable. And really two instances. One, comply with the FBAR obligations. That's pretty apparent from how brazen this particular defendant acted with respect to his disclosure. But the other way to handle this is to not simply not respond, not to file a responsive pleading, not filing an answer, not contesting the claims, because essentially whatever the government says, that's what goes. And the next things that we're going to see in this case are essentially the government maneuvering to actually secure the funds, whether those are in the United States or some legal process in France to actually affect judgment or affect collection on the judgment. That's going to be the next step. So really avoidable, but I think this case is an interesting one because it shows both what the process is if a defendant doesn't respond. If there is a default, there is a default judgment. And I think it also gives us a window into how taxes are treated in the United States and how important it is to actually report things correctly. So if you found this video any combination of interesting or educational, I'd really appreciate it if you would like the video and consider subscribing to my channel. And if you have any questions, feel free to reach out to me. I'd be happy to talk with you about any legal matter that you might have. And I look forward to seeing you in the next video.